Your Honour, Tara Patmore, an Environmental Health Officer from the Hollyoaks District Council. I'm here prosecuting an apartment complex near a neighbouring park in the Hollyoaks District for having a cooling tower which wasn't maintained properly and caused a few people to get sick. So we are prosecuting under the Public Health Act, Section 117, the owner of any premise where any registered system is installed must ensure that the system is operating and maintained in a manner that does not pose a public health risk. So we're basically prosecuting them saying that they did maintain their cooling tower and a lot of people get sick.
Do we have a defendant?
Yes.
So this matter's for hearing today, so do you maintain your plea of not guilty?
Yes, sure.
Be careful, you lost last one.
Okay, so how many witnesses do you have today?
So we have got the EHO which responded to the call. We went out and investigated it. We have the testimonials of people that got sick are coming in as well. And did you want the evidence that we've got now, just the people that are coming in?
Yeah. Yes.
You've got the manager of the apartment complex and also the operator, maintenance officer that they're going to service.
And are you calling a doctor in relation to the sickness of the...
Good idea.
Okay. So who's going to be your first witness today?
Sure.
First witness is Madeline, who's the EHO.
I need to take some notes with me, if it's okay.
Yes. Okay, so Madeline would be sworn in, or she needs to be sworn or affirmed, so if you don't want to do this one, you can do the affirmed. And you don't need to say. But you
I
can
say.
You say? Yep. Okay, so now you're good to go.
Okay. Madeline, could you state your occupation?
I am an environmental health officer at the Hollyoaks, I think it is, District Council.
So I can't ask if she went out on a date, no, because that's...
Well, what you can say is, first of all, you need to establish that she's an expert in this. So you need to ask her how long she's been in that position.
How long have you been at the EHO?
I have been with council for 25 years now.
Ask her what her qualifications are.
What are your qualifications to be an EHO?
I am a qualified environmental health officer from the University of Tasmania.
Okay. So you just need to make sure you cover the expert.
Okay.
And then you would say, something like, can you tell us what your duties include?
Investigating noxious odours, immunisation, food safety, water quality testing.
And if you want to avoid a leading question, you can say, and you've got a complaint, so you can say, I'm calling you in relation to the complaint of blah, 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 what can you tell me about that? And then she can launch off.
Okay. So I'm calling you on a complaint that was lodged on the 14th of July 2012 regarding a possible Legionella outbreak from a cooling tower in an apartment complex in the Hollyoaks District. Could you tell me about that?
Some residents from the apartment building in surrounding parkland, as well as people in the parkland, were complaining of a noxious odour in the area, so they called council.
And what was your response to that?
We sent 2 EHOs out to investigate the site and try to determine where the source of the noxious odour was.
Did you investigate the cooling tower in question?
No.
So you didn't go to that's not...
No, because we had no reason to investigate cooling towers.
Okay. Well, this isn't a very good defense.
I know, we encountered a problem here, haven't we?
So basically, if she said yes,
Yes.
we could say, what did you get testing done?
We asked for maintenance records of the cooling tower and found that it had not been correctly maintained as per the maintenance schedule. We then did water quality testing of the cooling tower and found that it had excessive levels of Legionella bacteria in the water.
And so, test results.
So you would say,
Are these okay to
commend
continue?
it? Yep, you could say,
Well, they're not actual results, but you can have a look at my big paper.
Yes.
Yes? Stand away. Are you aware of any medical testing that was done on the complainants?
I understand that several of the complainants had blood tests done to confirm if they had in fact contracted Legionnaire's disease, and 3 of them had.
Okay. So can I ask a question like, because we're coming, in the case study given it said it was a noxious smell and then their vomiting happened straight away, so even though I don't believe that that's from the cooling tower from
We're just making
Legionnaires,
stuff up here.
even though we've been out and tested it and there is a concern, can I ask a question like, so basically, I want her answer to be that even though the smell wasn't from that, the investigation that went into that found that the cooling tower was faulty. Does that make sense? Do you know what I mean?
yes. First of all, the last lot of evidence that Evelyn gave about, I understand, that people were sick, she wouldn't be able to give that evidence.
Okay.
She'd be objected to hearsay.
Sorry.
No, that's okay, because she didn't see it, so she didn't see that
Yep.
people were sick because she didn't go out there, and she's not a doctor,
Okay.
so she can't give that evidence.
That's
So you
something
have
on
to
the
call.
doctor.
That's
Yep.
right. In relation to your question, she's been put through as an expert, so she can give it evidence in her role as
Okay.
an EHO. So she can give evidence of, in your opinion.
So basically, my expert opinion is that the smell was not caused from the cooling towers, although investigations into the cooling towers.
Provided her qualifications allow her to say that, and I don't know because she's only got a degree from university.
Whoa, yeah. Not cool.
No, it's all right.
Is it strictly relevant? Is it strictly relevant? Is it
The,
relevant that she has an opinion that the smell
so
is unrelated to the cooling towers?
it's just that the concern was raised from the smell and people vomiting straight away. So the concern was raised that a noxious smell
Allergic to such
It's alerted and people got sick. So it's basically what Richard did for the plastic factory. But then we're looking at it from the cooling towers point of view. So we don't believe that the smell or the vomiting was from the cooling towers, but upon investigation of those cooling towers, we then found that there's a Legionella in there and other people have got sick from that. So the concern raised has led us to investigate and then find this.
But you don't need to take it any further than that.
Okay.
You originally alerted to it because of the smell, but
So we
that became irrelevant. But what became relevant was that the cooling tower hadn't been properly maintained.
Okay, cool.
You don't
So
take it further.
that's all
So
I'm
that's all
trying to
to
say.
say.
We found this when we were trying to find something else.
Yeah.
Effectively.
So that's the court doesn't deal with that after.
It's just a different matter now.
Right.
Just stick with the charge. The cooling tower. The circumstances that came to your attention could just be outlined.
Yeah.
Okay, cool.
Unless you're relying on them in some way. You're not relying on those smells anyway, really.
So can I just clarify? Does that mean that the sickness has got no connection to the
We've tested people, other people, and they did have Legionella.
right? Okay, so the actual people who are vomiting would not be witnesses because they're
No,
not going to be
but
relevant.
other people that have come forward that we had tests done.
Yep.
Hypothetically.
So the defendant, if you finished with her, the defendant gets a chance to have a go at her now.
No question.
No questions. So you would be relieved?
And so then can I call the doctor
Yep.
to ask him the question? I don't have a name. I then call Dr. Smith to the witness stand.
Yes.
Yes.
I swear.
Oh, you could have. Dr. Smith, Are you aware of concerns and people coming forward with Legionnaire's disease around the 14th of July 2012?
Yes, I am.
And
I'm trying to be helpful here.
did you treat people and get tests done on suspected Legionnaire's disease? Oh, that doesn't make sense. Where's my English from? And did you test people that were suspected for Legionnaire's disease around that time?
Yes, I treated 3 patients on the 15th of July who came into the emergency room with suspected Legionnaire's disease.
And what were the results, please?
The blood tests confirmed for all 3 patients that they had contracted Legionnaire's disease.
Tests. This is like they attended and it's signed.
If it's not, if he says no, you're in a much better position than the last time because he would say, no, I'm not. So you would then say, can you please show this to the witness?
Okay.
Okay, so you're safe.
And then what would I do?
You would say, she would say, can you tell the court what this is? And you would say, these are the results. And I'll
That is a blood test that I forgot to sign.
You don't need to, she doesn't have to tender it by consent. In fact, you did some leading because you said to her, you know, Legionnaires, etc. If you're not quite sure how to jump in, you can start by, once you've got the qualifications out of the way, can you tell the court what this is?
Okay.
Yes, this is. And you can save yourself having to work out how you're going to cover yourself
Yep.
by getting a verbal document and say everything that she's just said, and then seek to be tendered. And the defendant's not going to be able to, is going to have a much harder chance of opposing that being tendered because he can then cross-examine the witness if he's got any actual issues with that document.
I imagine that gives you a little bit of thinking time too.
It does. And so it can be quite useful when you've got a witness. Just give them that document straight away, tell the court what it is. They know what they're doing. They can do their spiel. You can ask questions as you need to. You can seek to be tendered, even if the court won't tender it. They can do mental blank. What do they call it when you hold it before you tender it? Mark it for identification, which means the court can still see it, but they're not officially tendering it until the defendant's had an opportunity to cross-examine the doctor as well.
Yep.
Okay, so you can make life a bit easier for yourself. So tendering by consent is not always the easiest option sometimes. Especially if they're saying things like, I'd like to have notes. But let them have their notes. All right, yep.
So what symptoms do these people come forward with?
I need my notes.
Anyway, they had coughing and that
Yeah.
sort of stuff.
They had coughing, chest pain. They had sudden high temperature, chills. Some had a dry cough. All 3 of them presented with a headache, stomach cramps, diarrhea, aches in muscles, and a feeling of being confused. They also had respiratory problems and pneumonia.
Can you confirm that these are all symptoms of Legionnaires?
Yes, they are typical symptoms of Legionnaire's disease.
No further questions?
So the defendant will not be asking questions if you wanted to.
Can I ask this?
Oh no!
Is it true that on that particular day you were under stress?
No,
Not
not at all.
Had you not been held up by the police coming to your surgery that day?
No, I had not. Okay, I'll make John's life a bit. Yes, I was held up. I was pulled over by the police on my way into work that morning.
And so you were a little stressed.
Yes.
And the notes that you made, could I suggest to you, or when did you make those?
I made those notes approximately an hour after I consulted with the patients when they came into the emergency room.
How many people were there in the waiting room?
About 35.
Will you not be becoming agitated because you couldn't receive the next interview?
Quite possibly.
Could I suggest you didn't?
Sorry, Tara.
Suggest you didn't make those notes contemporaneously. You made them the next day.
You may suggest, but I refuse to accept your suggestion.
Could I suggest that they do not represent true record of the state of the patient?
What do you say when you're sitting in here and someone says that to you?
You have to tell the truth.
Really?
bitchy about then going, come on, mine, you know, stop pressing her about that.
No, it depends.
Sorry.
It's unusual for you to press a doctor or an expert, but it does happen, and you can.
So he's trying to destroy my credibility as a doctor.
Those are perfectly reasonable and relevant questions. Very, very reasonable and relevant questions, and given quite politely too. Much more politely than you might get them. So you do need to be aware that the defendant could put things to you that are offensive.
I didn't mean anything.
Sure you did.
But they could say, isn't it right that you were drinking that day, or isn't it right that you've already been told that you'd only get paid if you...
Would they have to get blood tests proving blood alcohol to prove that I was drinking that day, or can they make claims like that just to fluster you?
They can make claims.
Isn't that like a leading question?
They're allowed to
They're
cross-examine,
allowed.
yeah. So a good cross-examiner only leaves open yes and no. They don't want the witness to expand. And if the witness starts expanding, you try to shut them down because you want to keep them, you want to trap them into destabilising the prosecution case, and they only need to do enough for the magistrate to go, that doctor seems a bit dodgy, something's not quite right about those notes aren't
Not even a real doctor, okay, I get it.
right. Especially something like which you brought up, contemporaneous notes. If your notes aren't made contemporaneous, they'll probably get chucked out, and it will come down only to your memory. So it's very important. Those are very important questions. And if they do that and the document can't be tendered because it's not contemporaneous, then you've weakened your case and the defendant's done exactly what he needed to do.
So the whole of this, the magistrate's court, is purely on swinging the mind of the magistrate. That's all it is.
Persuading based on evidence.
Persuasion.
Yep. And that's why I've said it so many times, preparation is everything, because you need to have a better case to persuade. So you can't leave any holes. You need to have everything covered so that every time the defendant tries to pull a fast one, you can go, yes, here's this, and here's this, and here's this. So once he's cross-examined, if there's anything out of that came up, you're allowed to re-examine. So he's brought up a whole new thing. He's brought up this whole thing that you hadn't even covered, which is she's incompetent. So you're allowed to ask him questions about that. To try and save your case.
Has it been established that the people that the doctor is talking about are the same people who are exposed to the cooling tower?
They're not the same people. I'm taking that they're different people in the same neighbourhood.
So you probably need to call those people and say, yes, we saw Dr. Madeline.
So she can get up.
Please.
Or should I ask her if she believes she's incompetent?
No, I don't really think I am.
Previous have your qualification.
No, you might want to say something in response to that. You might want to say, did the fact that you were busy in any way compromise your investigation of this matter? You say no. It's all good.
So the whole time the defendant can ask leading questions and the prosecutor can't.
Yeah.
For their witnesses.
Yeah. But once the prosecutor is cross-examining the defendant's witnesses, they can leave as much as they like.
Sorry. So now we can call forward the patients.
Yep.
Is that all?
Yep.
We now call the patient, Madeline.
Do you think it was best to call the patient before the doctor?
I would have called the patients first.
Okay.
Yeah.
So the patient has the symptoms, the doctor interprets the symptoms.
Okay, yeah.
Okay, so you would ask their full name and occupation.
Okay. Can you please state your full name and date of birth?
Jane Doe, 30th of June 1984, and I'm a childcare worker.
Can you state where you reside?
On level 3 of the apartment building across the road from the park. 1 Smith Street, Holly Hock, whatever it is.
Can I ask a question like, have you seen a doctor? Or is that?
Well, I would be, like I said, I would start something to say, can you explain to the court why you're here today?
Can you explain to the court why you're here?
I contracted Legionnaire's disease and had to go to the hospital for treatment.
Can you tell me on what day?
So I began displaying symptoms of the disease on the 15th of July 2012.
And what symptoms are these?
Shortness of breath, coughing, some vomiting and headache.
Did you go see a doctor or go to the emergency room once these symptoms?
I went to the emergency room, and when I was seen by a doctor, where I was then.
Can you state the name of the doctor?
Dr. Madeline,
Um,
who looked very trustworthy.
would you say her diagnosis of you was thorough?
Yes. She did a full, what do you call it when you...
Examination.
Examination! She did a full examination of me when I arrived at the emergency department, and yeah.
And upon diagnosis of Legionnaires' disease, you've then got medication which is...
Yes, I was given treatment for the disease,
Okay.
and has since cleared.
So you believe that Madeline treated you in an appropriate manner?
I do, yes.
Any further questions? Please don't ask anything.
So just on that, obviously to ask a question, you wouldn't be able to ask it. And you probably also want to cover where were you living when you contracted it, because you want to confirm that she was definitely still living there when she actually got it.
Yep.
So that the defendant doesn't say, oh, she was staying at her mother's. It's just a... but other than that, that was quite good.
In the interest of time, I'm going to ask more questions.
Okay, so she's relieved. She's okay. And she can
Should I
get...
stay here? Do you want to call anyone else? Okay.
She can get court costs, so you do need to be aware that if you've got a witness who's had to take time off work, you can ask the court to pay her for her time. They've got nominal amounts, so you get the paperwork to help with that. So is that your case?
That's my case.
Does the defendant want to call any evidence?
No.
I'm going to find you guilty. The medication worked. So
Oh,
in
it
the-
did, yes. I feel sorry.
I've got the report about the Legionnaires. I've heard expert evidence from the worker who came. And although the doctor's abilities is put in question, at the end of the day, the medication works. So,
It's only a new test degree, come on.
so then you would, I've heard the case, you would tell me if there's any prior convictions, just in the same way that we did before. And I would convict. Do you have any opinions about the penalties?
Ooh, yeah, go all in.
We are all in.
We're getting everything. So I can ask for court costs.
Yes.
Yep. And because the council has engaged the apartment complex owner previously about not maintaining their premise according to the guidelines, can we go maximum penalty?
Don't ever say, can you?
We are
We are seeking. Yes, we are seeking. And then he would have an opportunity to give his plea mitigation.
Just because I gave that determination.
And once I've heard all that, I'll weigh up what sentence I'm going to pass down.
And might there be circumstances in which you would reserve your decision?
Yes, I might. I might reserve my decision and decide that I need to go away and think about it and get it come back in a couple of weeks before I decide to or not guilty. Or I might say, look, I need to think about the sentence. No, I might reserve that and get it come back. And if you're not sure what your costs are, if you don't have a piece of paper with all the items how much it's going to be, you can ask for your costs to be attended, sign and die, which means you haven't quite worked it out. You don't know if you're going to follow it up, but if you do, you're bringing your case to follow up.
Yeah, we'll go.
Please tell me about it.
Questions?
I've got observation. This is so much more intense because it's Legionnaires and people die from that. Much more intense than containers being dropped or littering. So the whole gravity of the situations are much higher. The requirements of proof are much stronger. There are a lot of other considerations as to whether people are covered or not. The mood changes quite significantly the more the penalty, the higher the penalty and the higher the consequences.
And if someone died, it would have gone up to the Supreme Court.
Oh, okay.
I think that from looking at the legislation, if you know, there'd actually been death or something, it would become an indictable offence on a petty offence and you wouldn't have the Supreme Court originally.
Well done. Well done.
Thank you.
Well, now we've got the last prosecution, which involved a number of characters.
Cast.
So, we've got an actual defendant and his counsel.
Well, there's the police and there's ice in there, as far as I see.
So, Amigo, introduce yourself to the magistrate.
Your Honour, I'm Amigo Huber, an Environmental Health Officer with the Holly Council. Whilst attending the park.
Hang on, sorry, I'll just stop you. When there's a lawyer on the other side, you simply give your name and then they get to go and then you do the skill.
Yeah.
So you get to introduce yourself.
Hi, I'm Icy Man, the employee in the ice cream cart.
Okay. So then you would introduce yourself.
Your Honour, whilst attending the park on another matter, we noticed some people, a man and some children being sick. And so we concerned, we asked them a few questions and it turned out that all consumed ice cream from the same ice cream van. We very quickly went and talked to them and obtained some samples which we sent off to a lab and received a certificate of analysis from the lab which I can present to the court right now.
Okay. And has the defence counsel seen?
No.
Just analysis from the samples.
Okay, so how many witnesses are you? Which witnesses are you?
Well, I'm not sure how many children there were. I'm going to say there were 3 children and Alex, the man who also consumed some ice cream. And I'd like to call these witnesses and I would be asking them, did they all consume the ice cream? Was there anything else they consumed that day and established that they ate nothing else in common? So,
How old are the children?
it doesn't say. And also, I've got some medical reports because they were diagnosed as all suffering from the same illness.
You just need to be aware, it's probably the side point when you call children as witnesses, the court doesn't like to see children in
Okay.
these boxes, especially because then they get cross-examined.
Yeah.
It's pretty tough. If you have to, you have to.
Yeah.
But you do, obviously, for sort of 15, 16, it's not a problem, but if you're talking about 9 or 10, you do run into the same issue about the actual competency.
Even though it
in the
seems
evidence.
fairly simple in that did you eat your ice cream, did you eat anything else, then they might get cross-examined.
Yeah, and when they're very young, the law says that you have to understand the importance of telling the truth in court to be a sworn-in witness. So, you know, we'll assume for the purposes of this that we're dealing with teenagers that are 15 years.
Yeah.
Just need to think about this.
And so, yeah, I know also had a diagnosis from a doctor saying they're all suffering from the same illness.
So you're going to call your children first?
Yep.
Right, so, and then you call your doctor?
Yep.
And then you would call your analysis guy who's done the analysis.
Okay. And when will I actually state the charges that we're charging under?
That's pretty much what you've done
Yep.
when you've said what's happened. So
Okay.
I've got the charges in front of me.
Yep.
I've got a complaint in front of me because you've laid a complaint at court.
Okay.
So that's in front of me, and then you're basically saying this is what we allege. because we're prosecuting this matter.
And I also want to state that I want to charge the manager is in the ice cream van with one charge, but the actual company with two charges, one of which is the same charge. But
so what we would have is we'd have two complaints.
Yeah.
I'd have two pieces of paper. Effectively, you'd have joint defendants. So you'd be saying, in this matter, we've brought a complaint, whatever number, against the manager, and also brought a complaint against the company. We're seeking that both matters be heard at the same time because all the witnesses are the same. So you're actually effectively running two hearings.
And obviously the defence would know what charges they're defending.
They would know because you've served them well before you're in court. So you'd simply say, we've charged two parties and we're seeking that they be heard jointly so that the evidence only gets heard once rather than doing two hearings.
This sort of benefit, it's like 14-2, should have known food was unsafe, and 21, which is your compromise that the food standards go.
It's always good to let the magistrate know what it is that you're alleging because they don't necessarily, they're dealing with hundreds of legislation, so then they know what the issue is. So then I would ask the defence lawyer, you maintain your plea of not guilty. And I may, sometimes courts do this and say, well, what's the issue? So they might actually, rather than putting in proof at once, they might say to the defence, can we name any issues? So what's the basis of the defence?
Well, as the employee in the van, I was only a fill-in employee. The appropriate employee called in sick on the day, and as a food handler, they obviously can't be working while they're sick. And I was operating within all Food Act regulations, including hand washing and using wipes to handle the food, using food grade sanitisers to clean the benches and utensils, and storing foods correctly. The fridge that was storing the ice cream was faulty, but I was completely unaware of this. So the responsibility should not be on me, it should be on the owner of the vehicle and the business, because I was doing everything within my power to serve the food safely and suitably, and nothing I couldn't have done anything better to have changed that.
Well done.
Diligence.
Yes.
And what about the business owner?
Yes, ma'am.
I was completely unaware of the faulty refrigeration.
So we've got two defences. All right. Now, you would call your witnesses. I assume we're not going to do that now. We're just going to assume that happens.
Yeah, well, I'd basically, like I said, I'd be asking them whether they all ate the ice cream and whether they had anything else that was in common to cover saying, oh, well, if there's a dodgy takeaway shop across the road, it's probably that.
And so you give us all the analysis stuff. Is either the defence going to take issue with the analysis or are we going to agree to that by consent?
That's fine.
Okay, so how are you guys going to get around the loophole that they're both saying that they didn't know anything about it?
Well, under the charges, it says that it's currently section 4, but you can charge an individual or corporate body, but it just says a person must not sell food that the person all agrees admit to know is unsafe. Like, you should know if the fridge isn't working, if your ice cream is melted, and all that sort of thing, so they should know that it's unsafe.
So we're dealing with the mens rea case, which is what Pete talked about last time, which is you have to have some knowledge and some intent for what's happening. So you need to, when you're doing your case, the questions that you need to ask the experts was, when you looked at the fridge, was the ice cream melted?
Are we targeting the owner or are we targeting the employee here?
You're going to be targeting both separately. You have to think of them as two
Employee,
separate
one
hearings.
charge,
So you have to
employee,
prove the case against both of them. So with the employee, it's likely in this particular scenario that a lot of the analysis and stuff can all be peanut butter and sense. It's all going to come down to knowledge. So you need to think about with witnesses. Well, did your ice cream, like with your children, did your ice cream have a funny smell? Was it all melted? Anything that might tip someone who's working off that actually something's not quite right.
That's it. And the van is dirty as well. Quite obviously dirty.
So you need to stand up all your ducks, so that when she gets in the witness box and says, I didn't know anything about this, you can cross-examine. So you're going to win your case unless she gives evidence. In this case, she's going to have to give evidence, and you're going to get to cross-examine her. So I don't know if you want to do that or not, or just pretend it happened.
Could you gain credibility whether she's believed or not?
Yeah.
That's the judge's role.
Would it be easier in this case to prove against the owner in that they should do regular checks and maintain and supervise it than a casual employee who was just brought in for the day? Just a query.
I would think there's issue an infringement notice, which is like a sort of slap on the wrist, a small fine of 1 to 10 penalty points. And I think in this case that might have been a good option, and then go harder.
She might say, I'm not going to pay it. I was a ringing. I didn't know anything about it. In which case you are going to end up in court, because she's got a pretty good defence. Or possibly has a good defence if the machine was working and the ice cream was all right and she just didn't notice.
Can I ask a question? Could the freezer have been faulty a previous day? Because her defence being the freezer, she wasn't aware because the freezer was faulty in a previous date. The ice cream was then defrosted or whatever, which made it contaminated.
Yep.
Then when she got to it, it wasn't rock hard, but it was still a bit soft, which she then determined to be adequate. And was unaware that it had previously been defrosted and refrozen, therefore sold it.
And I would dismiss the case against her.
Good logical thinking.
No reasonable person would have thought there was a problem in that situation. And that's what the magistrate has to be content of. Would a reasonable person have thought she was going to be making people sick to hand out their ice cream? If it's hard, if it's not melted, if there's no weird smell, then a reasonable person is going to think that the ice cream's fine. So she's safe. The person in more danger is the owner, because in that sort of case you're saying he missed the routine checks. He had a report saying that the ice cream was no good, that it needed to be fixed. He was cutting corners. All of that sort of stuff can show you that maybe he did have knowledge, because he's required to under the Act to take more precautions than the employee. He has a higher standard of care.
Well, it would be a good defence so that she actually checked the freezer that morning, the temperature, and it was within the normal range. So then, as far as she knew, it's fine.
She's in pretty good hands. But the owner's got to explain why he hasn't done what he's supposed to do to keep this fridge and ice cream van in better nick.
So in this situation, the prosecution really shouldn't have brought 2 charges. It should have been just primarily targeted the owner.
Well, not necessarily, because they might not have found out some of this stuff at the time.
I possibly think I would have cross-examined and said how melted was the ice cream. You could have said it was frozen.
That's my reservation. As the EHO, we've been speaking to the parties beforehand, taking notes, evaluating whether they're lying or not, and then make a decision whether they were innocent, not go against the employee, concentrate on the owner. Or there may have been something that alerted you to the fact that the employee is lying to you and the story's not consistent.
And if she's lying, then you have to bring her to court and let me decide if she's a liar or if she's telling the truth. So your witnesses could be saying, the children could be saying, it was melted and it smelled disgusting. And she could be saying, no, it was fine, I checked the temperature. And then it's my job to say, yes, I agree with you, or yes, I agree with you.
In that instance, is that when it's less reliable to have children as witnesses? If there was a child saying, it looked funny, or anything, but an adult saying, no, it was fine.
It depends on the child, because like I said, all witnesses are deemed to be competent witnesses, but children under, I think it's can't remember, it's about 9. The prosecution actually has to prove that they can give sworn evidence, so they can actually be sworn in, because they have to know the importance of telling the truth in court and how that's different to telling the truth to your mum or something like that. And if they can't do that, then it's called unsworn evidence, and unsworn evidence has less weight. So that would happen in a situation where, they know that they have to tell the truth, but they don't understand that it's more important in court than it is with your mum. So if you're dealing with an 8 or 9-year-old, then the court can't give it the same weight that they can give an over 18-year-old. But if we're dealing with a 16-year-old and an adult, then no, the court's going to give it the same weight because there's no issues about confidence.
I think you should trust your common sense. But ultimately, it's the judge who decides what weight to give to the evidence. But trust your common sense in getting to that point first.
I'd also like to argue that you ought to reasonably know that in basic food handling, that food doesn't have to smell or look funny for it to be contaminated with bacteria or something. So,
and that's where Olivia's question about she actually did the right thing and actually checked the temperatures. That adds to her reasonable belief that because she's actually taking the right steps, then that improves her defence if that's believed by the court because she's actually doing her job properly.
Yeah.
But something in the machine has gone wrong.
It's not said in the brief that the children enjoyed their ice cream and finished it. So the children is
So maybe
It's very
it's an example of something's gone wrong 3 days ago, and it's refrozen, and no one's really noticed. That can't possibly be. She can't possibly be held criminally accountable for that.
The other thing about quite strange is that this is an actual case, so it's that they were diagnosed as having a virus, and everything points to this being resolved in the ice cream. I don't know virus is
There
like
will be a virus.
ice cream.
No, I'm going to question that as well.
So the expert who you call who says, yeah, the virus is in the ice cream is probably going to be annihilated.
Yeah.
And
It's
be
more-
very heavily cross-examined by the owner and the...
If it was a virus, I'd go harder after the employee because obviously viruses usually more come from like colds and things like that, and they were working while they were sick. So the employer might go, well, I didn't know they were sick. Like,
It's going to be so in that situation. You're not going to prosecute both. You're going to make a decision.
yeah.
Of course, there's going to be situations where both are responsible. The employee knew about it and had been continuing to work there, and the employer wasn't getting the benefit.
Because people actually got sick, I would definitely go after the 2 charges against the employer, and I would expect to totally win on the section 21, which is they must abide by the Food Standards Code, which one's about temperature control and one's about keeping a clean sanitary environment. We clearly haven't done that, and the one that's ought to have reasonably known that the food was unsafe, that would be the one that was a bit hazy, but in my eyes personally, that's how I said it. They ought to have known that this would have made people sick. Ought to reasonably have known, said actually, which probably makes it even more messy. Those 2 words, ought to have reasonably.
Yeah, what would a reasonable person in the same circumstances have thought is the test. The owner's going to have to prove that they actually did everything right, and to get a charge, they probably have to prove that they did everything right. They were with all the standards. They got a mechanic to come fix it who was certified, etc., and the mechanic's done a lot of things, something like that.
Yeah. I suppose another powerful evidence, like you can use like photos of the grind.
Yep, you need your analysis of the ice cream.
Yeah.
Photos of, if she's getting in there saying, oh, it's perfectly fine and the ice cream looks great, and you've got photos of, rat poo or cockroaches or something like that, then you start to unbalance her credibility. And maybe she should know this. Or, get photos and she's got gangrene all over her hands or something like that.
I also found an interesting one, Section 31 of the Food Act, alternative verdicts for serious food offences, where under Section 14, which is the order of known it's unsafe, which is quite a harsh penalty, it says that the trier, who I suppose is the magistrate, can find them guilty of offence against 16, Section 16, which is not quite as serious, which has to do with I think that's actually just says must not sell unsafe
Yeah.
food. There's no order of reasoning, no, it just must not sell unsafe food. It's got like half the penalty.
So
There's that.
if you're running that in court, what you would probably do is she gives her defence and you think, oh, crap.
Yeah.
And at the end, the magistrate would say, do you have any submissions to make?
Yeah.
And you would say, in this case, I'd like to point you to section 16,
Yeah.
that Your Honour has it open to you to find the alternative charge of, and I would submit that Your Honour can do so because it's been proved that she was a seller on the day, it's been proved that the place was unhygienic, and it's been proved that the children remain sick.
Yep.
The minimum penalty and maximum penalty of that is blah blah blah. The defence can have an opinion about that, but you can, and you should, let the magistrate know if there is an alternative available to him, and then you still get.
In some cases, if someone's really going after someone, I won't tell the magistrate about that.
But you probably should.
Yeah.
Because otherwise you run the risk that the magistrate goes, well, it's just dismissed, and they don't know that they have an alternative.
And it's about, I suppose it's all about, that principle of fairness. You might think it's the best thing to leave to the magistrate to decide whether they ought to have known or whether the lesser penalties are big. Instead of just going for the lesser penalty straight out, you might.
Well, you are still in the magistrate's side, but you are letting him know or her know that if he or she doesn't think there's quite enough, that there is a lesser option available to them, and and they may come back and say, no, I think you actually got enough to prove that you ought to have known, or no, you haven't, so I'm going to strict liability penalise.
Can I ask a quick question? Because food vans get registered in the municipality in which they're housed, say if they get registered in Devonport and then this Iceman van has come down to Hobart, would the Hobart Council have the jurisdiction to take Iceman to court, considering that they're not registered in their municipality, or would it be the Devonport AHOs that would then have to consult with the Hobart AHOs to prosecute?
That's a good question because it says Licey Man is in charge of the van. The owner of the business lives in the neighbouring council area, and the ice cream business is run from a factory in the neighbouring Downcast council area. So there's
Because they're also
there's three councils involved, potentially.
I would assume that you'd allow to prosecute under not be able to sell safe food if the van wasn't registered. They have to be registered to be able to prosecute under the Food Act.
I don't know the specific legislation, but there's a general principle that's jurisdictional. So what happens within your jurisdiction is your responsibility.
Okay.
Does the food equal need like a period of permission to sell food outside its jurisdiction?
But once they're registered in the municipality where it's housed, they then can operate statewide. So
Oh,
it's
they
state.
go anywhere.
Yeah.
Is that somewhere that you need permission for the parks and things like that? Like in those things, I think. So,
You have to notify council that you will be in there, but I'm not sure if they can say no
Yeah.
because you have that registration. I'm just wondering if it has any, like there's a bit of a loophole.
I'd imagine they transfer the enforcement to wherever you're operating in.
Yeah. Okay.
These are all very valid points, and of course that obviously in the case study.
Makes sense. Otherwise, how could they gather the evidence back in Devonport for what happens in Hobart?
In fact, if there's something like that, it will be circulating in municipalities constantly.
So that's the case.
We'd be saying that clearly contravening section 21, they're not abiding by the food standards codes. Look at the dirt ban, look at this. I'm not quite sure what evidence we tender about how we knew the fridge was
well, it just says that the
electrician or something, and that, that's pretty straightforward.
Laser thermometers might have taken a reading and found that the gauge on the freezer was wrong, and then in fact the freezer was much warmer than it should have been, or something like that.
So if it's correct.
So would the employers still be guilty? Like to me they are, but like they don't know, and they're just an employee. Like I'm thinking of someone that just has a casual job, like.
I sort of treat that as like a person must not sell food.
Yeah.
Like it's almost like,
Yeah,
sorry, it
that's
doesn't matter, like you're a person
I know,
who's selling food.
That's what I
just seems a bit harsh.
Yeah.
Like if you put it in a McDonald's
Yeah, that's
setting
what I'm thinking.
and their fridge is not working, the manager knows that the fridge isn't working, the employee comes in and sells food that's unsafe without knowing, then turning around to that employee going, you have no idea that this is happening, bam, I'm finding you. It just seems a bit like if you put it in context.
Well, that also comes into plea mitigation. So if it was found that they were guilty, she'd be able to give a plea mitigation to the magistrate and say, I knew nothing about it, I was a casual employee, all of those things. So even if they were found guilty, the magistrate might take that all that into account, and they can do things like say, yeah, well, I found it proved, but I'm going to dismiss it, there's going to be no fine, or I'm not going to record a conviction. So you can, if it's not fair, the magistrate can say, well, look, technically, in line with legislation, she shouldn't have done it, but I'm just going to prove and dismiss or give her effectively give her a warning, so that she doesn't do it again, as opposed to actually saying, I'm going to fine you. And the magistrate's got that power.
There is a general principle of law called vicarious liability, whereby employers are responsible for the actions of their employees.
Yeah, that's section 105 here.
So the legislation specifies as vicarious liability, then the employee shouldn't be prosecuted. It should all be directed to the employer.
Yeah.
Depends on
I just realised after it was basically saying, like, you do that as well, not just you pass it.
There may be circumstances where the whole idea is to prosecute the individual employee because they're maybe the only ones who have got control of the situation. But the general principle is when you do something wrong at work, unless you go beyond the scope of your employment, like you act totally contrary to your instructions and your training, it's normally your employer who is responsible for anything that happens at work. You've got a frolic of your own, as well, so.
But I think it's perfectly ended for an infringement notice. If I was an HO, it's like that slap on the wrist. If she wants to come to court and argue it, then fine. I'll go. I think under circumstances, infringement notice is appropriate. You kind of should have known, but I've gone for a very much lesser penalty, which is like, maybe just like one penalty point.
Whereas if the place is clean and she's done her job properly, she's checked things and through no fault of her own, the employer has not kept the stuff to standard, you probably wouldn't give her infringement and you go to the employer because she's not into it.
It is hard, I suppose, because you're relying on someone kind of go, I'm not going to do this, I'm not going to work in this place, like I've been called in to do this job, but no, I'm not doing this because this man's too dirty. Like, you know,
And then not be broken anyway.
yeah.
So we work at 6.
Children wanting ice cream.
That's
That's
But if the ice cream is making people sick, do we have responsibility to serve like a prohibition notice or whatever to stop them selling it?
Yeah, we'd be totally in trouble if we didn't do that.
Yeah, if it's found to be
Yeah, it is.
contaminated, yeah, have to.
It says something. Initial prohibition is necessary to prevent or mitigate the serious danger to public health. So people are already sick. Before you just let them go on serving ice cream. I don't know whether that's something you'd probably mention in passing to the magistrate with certain prohibition order. But
Well, you probably would, if it's particularly relevant, so particularly if this incident happened, if you serve the prohibition before it happens, then of course you've just improved the case.
Yeah.
But if you serve the prohibition afterwards, then you are going to let them know, because it's either going to be a mitigating factor or an aggravating factor, because if you say we serve the prohibition and they've complied, then you need to let the magistrate know because that mitigates their culpability.
Yeah.
But if they're continuing to trade, or
That's
they've
a whole
ignored
separate
it,
offence in
then
there,
and the magistrate needs to know that if they decide, while they're deciding minimum sentence and maximum sentence. Because if someone's continuing to not comply, then they need to be hit harder than someone who's immediately done the right thing.
And if all the evidence indicated that this was a really chunky show, it was likely perhaps to lead to people being affected, something really had to be done to stop it. Do you as magistrate have any powers to issue injunctions or to carry on the penalties that are specified in legislation?
I don't know.
I think you're restricted to legislation.
Yeah. So if I do have it, then I then the prosecutor needs to tell me about it. So, if you find something like that, if you do want to bring an injunction, you need to make sure that you tell the magistrate, because the magistrate's probably not going to do it off their own bat. Even if they can, but I don't think it's an option of the sentencing act to have to be specific to the specific act that you
Yes, I imagine is the answer.
I can see the EHOs becoming potential witnesses to the civil claims, subsequent civil claims. So all the kids, all the people who were poisoned then sue the restaurant and claim damages. The EHO will be called as witnesses in their civil claims, quite separate proceedings afterwards.
Yeah, unless they've actually successfully criminally prosecuted, because then they can avoid the court of witnesses basically relying on the fact.
That's right, they're taken to the criminal prosecution.
So are we going to be going to
I'm going to dismiss the case against the employee. And I'm going to convict the employer. Sorry. Does the employer want to make a plea mitigation? Any excuses? No. Right then. So I'll just and no price.
That'd be both charges?
Yep, both charges. Yep. True. But I've got the employee is off. I believe that she's done.
Well done. Before you leave your chair, Your Honour, may I just say how grateful we are to you for the impartial justice that you've dealt out and for taking that role. It's been absolutely invaluable. Most grateful to you. Peter, for your support and bringing it all together, thank you very, very much. I'm very grateful. I think we've all learned a great deal. We've now got the benefit, thanks to Richard, we've got the recording of the whole exercise, so it will all be available for you on Marlow. You'll be able to go through it again and pick up all these points that have been elaborated and made so skillfully through the proceedings. So thank you all. Thank you, participants. It's been really wonderful.
And it was a very good effort, John. By the students, it was very good,
Yes.
first up effort.
Yes.
And they got the basis of good prosecution cases there. That's not easy to do, so they've done very well.
When you consider they've done it off their own back.
I think it's sunk in, it's like being there.
Yeah.
You haven't got that. Something to open on that down.
Right, well, that's the extent of it, I think.
Yes.
Do I have any observations or questions?
If you like those.
I have